Good afternoon, everyone. Hope everyone's doing well this afternoon.
Good afternoon, Your Honor.
Good afternoon, Your Honor.
Good afternoon, Your Honor.
Afternoon.
Good
Ms.
afternoon.
Bridgewater. Good afternoon. The SAP reset date.
February the 28th.
Thank you. We're going to begin in courtroom 3 this afternoon.
Yes, Judge. Thank you.
Okay, ready when you are.
Position number 3, Judge.
Okay. Good afternoon. This is Ms. Durham. Is that correct?
Yes. Good afternoon.
Good afternoon, Ms. Durham. I'm Judge Eric Morrow. This is the state court expedited accusation calendar that we're conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes.
Thank you. Ms. Durham, you've been charged in case 23 CR 000881G with simple battery family violence. Let's see, do we have pretrial on yet? Good afternoon, Mr. Rogers. Do you know the history?
Yes, Your Honor. Good afternoon. The defendant has a 2006 guilty plea for aggravated assault. It was pretrial diversion. She has arrest in 2001 for possession with the intent to distribute cocaine. That was dead docket 2002. Fulton County failure to appear was also dead docketed, and a open case for willful obstruction from 2023 in Fulton County. She has 6 total cycles.
Thank you. And this matter?
Yes, Your Honor. On February the 12th of 2023, officers arrived to the location of 130 Laushi Street Southwest. When they arrived at the location, they spoke with Miss Carol Parks, first name C-A-R-O-L, last name Parks, common spelling. When they spoke to Miss Parks, she informed them that her youngest daughter, Miss Terrion Durham, came to live with her due to Miss Durham being evicted from her home. Miss Parks advised that she didn't move in too long ago. Miss Durham asked Miss Parks to fix her something to eat, and when she refused to do so, Miss Durham then placed both hands on her chest and shoved her to the ground. This particular location, 130 Laushi Street Southwest, is a senior citizen facility, living home. We are asking that bond be set at $2,500 surety bond. Stay away from that facility and no further contact with Miss Parks. We spoke to Miss Parks, and she does not want to have contact with Miss Durham, and neither does she want her to return to that location, Your Honor.
Okay. Thank you, Mr. Rogers. Good afternoon, Ms. Gant.
Good afternoon, Your Honor. Ms. Terrion Durham is 40 years old. She has been in the Atlanta, Georgia area her entire life. She does have family here, but she states that there is no one who is willing to assist with bond for financial reasons. She has 4 children, ages 8, 5, 4, and 1. She is the primary caretaker, and she's not receiving any child support. Ms. Durham is also facing some housing issues here. She does state that once released, she will be able to reside with a friend temporarily, and we are putting in place a social worker consult for her to assist with housing resources. Ms. Durham completed high school, and she is scheduled to start at West Side Works, where she will be studying IT. She also is unemployed at this time, and the program that she is in, West Side Works, will also help her to obtain some type of employment. She strongly denies the allegation, John. She states that she is the person who called the police because she was attacked by her mom and her sister. She states that her mother has been mean to her, and that Ms. Durham was basically, she states that her mom got up in her face and that she was merely trying to get away. She denies striking anyone. She states that she has bruises from this incident as well. Now, I do acknowledge my client's history. However, I would bring to the court's attention that it's a very very remote history. In fact, the 2006 matter is pretrial debt docketed. There are no recent violent offenses, and I am asking today, Your Honor, for a signature bond on Ms. Durham's behalf so that she can get out and get her children back. We are unopposed to the no contact and the stay away orders, but we would ask for a one-time law enforcement escort so that Ms. Durham can retrieve whatever belongings she may have at the incident location. Thank you.
All right, it's going to be a $3,000 signature bond through the jail. No further contact with Ms. Parks. Stay away from the 130 Lawshie Street address. She can go back to that address on one occasion with law enforcement to retrieve any belongings that she might have there. No drugs, alcohol, or weapons while out on bond. Good luck to you, Ms. Durham.
Judge, I'm sorry, what was the bond amount again, please?
Say it again.
What was the bond amount again?
It's a $3,000 signature bond through the jail.
Thank you. I have position number 5 is next, please. Go have a seat on the second one for me.
Say it again for me.
Position number 5, number 5.
Okay, I don't know if it's me or if it's, I still didn't get the position number.
Aye.
Position number
5.
5. Thank you.
Thank you. Good afternoon, Ms. Goss. I'm Judge Eric Morrow. This is the state court expedited accusation calendar that we're conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes.
Thank you. Ms. Goss, you've been charged in case 23 CR 0008883Y with simple battery family violence. Let's see. It's my understanding that this is Ms. Goss's first arrest. Mr. Rogers.
Yes, Your Honor. On February the 10th of 2023, officers arrived to 3207 Washington Road, apartment 11 in East Point in reference to a fight. When they arrived, they spoke to Ms. Kiana Goss, who stated she wanted her boyfriend, Mr. DeAndris Stinson, first name DeAndris, last name Stinson, common spelling, to leave the residence that they shared. Officers explained to Ms. Goss that they could not require Mr. Stinson to leave the residence and that she would have to seek removal through a civil process. Ms. Goss then stated that it's best for Mr. Stinson to leave due to the fact that he had damaged property within the apartment. She showed officers that Mr. Stinson had punched a hole in the wall. After speaking to Mr. Stinson, officers learned that Ms. Goss did strike Mr. Stinson with an open palm to his face. And in reaction to that, Mr. Stinson punched the wall. She was arrested for being the primary aggressor. She did state on body worn camera that she did in fact hit Mr. Stinson, Your Honor. For those reasons, we're asking for a $1,500 surety bond, no further contact, a stay away order from that address. It is concerning to the state that Ms. Goss was effectively trying to have Mr. Stinson removed from that location. So therefore, if she is allowed to return to the location with him, this same situation could happen again, where it's violence and violence will occur, Your Honor. So that's the state's position.
Has your office spoken with Mr. Stinson?
We did reach out. We were not able to reach Mr. Stinson.
Okay, thank you. Ms. Gant?
Yes, Your Honor. Kiana Gauss is 30 years old. She has been in the Atlanta, Georgia area since 2018. She informs me that she does not have any children here, nor does she have any family members in the local area. Ms. Gauss completed high school. She also has some college where she studied veterinary science and zoology. She hopes to one day work in a veterinarian clinic. She is currently employed as a ramp agent at a Alliance grounds. Your Honor, she strongly denies the allegation. She states that Mr. DeAndris Stinson, the complaining witness, was actually going through her things and that he was approaching her in an aggressive and threatening manner, and she more so took measures to defend herself and her property. Regarding contact, Your Honor, I did reach out to Mr. Stinson. He is on the Zoom call. He informed me that he wants to continue having contact with my client, as does my client. Therefore, we are opposed to any no contact and stay away orders. As we heard from pretrial, Ms. Gauss does not have any prior history. Therefore, I'm requesting a signature bond, Your Honor. Thank you.
Mr. Stinson, if you are on the line and would like to address the court, now is your opportunity to do so. If you would, you certainly don't have to, but if you would like to address the court, I'll need for you to unmute yourself and activate your camera, and I'll have to swear you in. Are you with us, Mr. Stinson?
Yes, I'm here.
Good afternoon, sir. Can you raise your right hand for me? Do you swear from the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
I do.
Yes, okay. You can put your hand down. What would you like to tell the court?
I would like her to come back on any charges against her or anything. It was all an accident and a misunderstanding. It was a misunderstanding, really. That was all.
Okay. Has this happened before?
No, it's never happened before.
Are you afraid of her?
No, I'm not.
And you do want her to come back to the Washington Road address?
Yes, sir.
Okay. Thank you, Mr. Stinson. As such, it's going to be a $2,000 signature bond through pretrial per the judge, 1-day anger awareness, no further violent contact with Mr. Stinson, and no drugs, alcohol, or weapons while out on bond. Good luck to you, Ms. Goss. You also, Mr. Stinson.
Thank you, Your Honor.
Judge, we should go to courtroom number 2 next, please.
Okay.
Thank you.
Good afternoon, Judge Morrow. This is going to be position 8, Lucier.
Good afternoon. Good afternoon, Mr. Lucier. I'm Judge Eric Morrow. This is the state court expedited accusation calendar that we're conducting by video. Do you agree to have your case heard by video? Can you hear me, Mr. Lucier?
He's talking to you, Lucia. Yes, sir.
Okay, you have been charged in case 23 CR 0000873C with theft of service, giving false information to law enforcement, and willful obstruction of law enforcement. Is there a history, Mr. Howard?
Yeah, this is ninth arrest. Last arrest was back in October, criminal trespass. He has a TPO in his name. Victim in that case was a Summer Jacob. I got a 2020 out of New Mexico, contempt of court, failure to appear. 2020 ag assault deadly weapon. 2019 ag assault deadly weapon. 2019 resisting an officer. 2015 assault causing bodily injury, family member, conviction out of Texas. That's it.
Thank you. Good afternoon, Mr. Abdullah.
Good afternoon, Your Honor. The facts show in this case, officers were called to 977 Canton Street in Roswell in regards to a male trespassing and harassing employees. Officers made contact with 2 female employees who told them the defendant came into the store and made inappropriate comments and racist jokes towards them. The defendant entered the dressing room and came out with a vest on and no shirt on. The employees asked the defendant to leave and he refused, which is why they called the police. While the officers were investigating at 977 Canton Street, a waitress from across the street at 963 Canton Street, which is the Ceviche Taqueria, came and told officers that the defendant came into the restaurant and ordered 2 margaritas, a beer, a shot, a fajita, and an order of churros totaling $73.48 and did not pay. When officers asked the defendant to pay for his food, he told them that someone else in the restaurant told him that they would pay his bill. Officers determined that the defendant did not have the means or funds to pay for his food. When officers asked the defendant for his name, he told him his name was Nicholas Lucer. Officers contacted the actual Nicholas Lucer and confirmed that that was not the defendant's name. The defendant refused to give his name or date of birth to officers, but was recognized by an officer at the jail who was able to identify him. As you heard from pre-trial, he does have an extensive history. The bulk of his history is from is actually from the West Coast, which poses a significant flight risk because his last arrest was out of New Mexico in 2020, or I'm sorry, his most recent arrest out of the state was in 2020 out of New Mexico for a felony FTA. He also has an escape conviction from Texas in 2010. For this reason, the state believes that the defendant poses a significant flight risk. We're requesting a $2,500 surety bond. That's $1,500 for the theft charge and $500 for giving false name, an additional $500 surety bond for the obstruction charge. A stay away from both incident locations, 963 Canton Street, as well as 977 Canton Street in Roswell. And no weapons, drugs, or alcohol while on bond. Nothing further from the state.
Good afternoon, Ms. Kim.
Yes. Mr. Lucier is 37 years old, Your Honor, and he has no employment at this point. However, he graduated from high school. He says that he also has some college for a bachelor. We would like to request for a signature on bond. There was no violence whatsoever, and this is a theft of service. He believed someone was going to pay for his meal, so we would like, and the drinks. Only concern that I have is he is residentially challenged, so I will make sure that he gets a social worker service to have a visit and also have a BHET to make sure he is okay. That's it, Your Honor.
Your Honor, I would just say that we agree that there should probably be a BHET and possible social service visits, but that's best served if the defendant is in custody. If we release him on a signature bond, we may not see him again.
All right, for the theft of service, it's going to be a $500 good bond. For each of the other charges, it's going to be a $250 good bond. That's total $1,000 good bond. Stay away from 977 and 963 Canton Street. A social worker visit for a BHET, and no drugs, alcohol, or weapons while out on bond. Good luck to you, sir. Who do we have next?
Position number 12, Judge. She has a private attorney in the courtroom with her.
Hey, good morning,
Okay.
Your Honor. Bill Swank for Ms. Vickers.
Good afternoon, Mr. Swank. And you also, Ms. Vickers. I'm Judge Eric Morrow. This is the state court expedited accusation calendar, Ms. Vickers, that we are conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Ms. Vickers, you've been charged in case 23 CR 000875G with battery family violence. I'm informed by pretrial that this is Ms. Vickers' first arrest. Mr.
First
Abdullah.
Yes, Your Honor. The facts show that on February 11th, 2023, officers responded to 520 Forest Valley Drive. On scene, officers met with the victim, Zachary Wood, who is the husband of the defendant. He was standing outside of the residence with a suitcase. Mr. Wood told officers he was leaving because the defendant called the police and lied about him assaulting her. Officers spoke to the defendant and found several inconsistencies in her story. She also showed them a video of the altercation that showed Mr. Woods was calm and reasonable throughout the altercation. Officers did not see any visible injuries on the defendant, despite her report that she had sustained injuries. Mr. Woods, however, was injured during the altercation. He suffered cuts and bruises to his hand. Mr. Woods told officers he was trying to get his belongings so he could leave, and the defendant slammed his hand in the door and locked him out so he could not get his things to leave. This is the defendant's first arrest. However, the facts of this case are very concerning because the defendant called 911 and made a false report that she was injured. For this reason, the state is requesting a $3,000 surety bond, no further contact with the victim, a stay away from the incident location, 520 Forest Valley Drive, 1 day anger management, and no drugs, weapons, or alcohol while on bond. Nothing further from the state.
Mr. Swank.
Yes, Your Honor. I think, my client was having a quarrel with her husband, who I believe is on the Zoom. I think he was provided a Zoom link.
He is here, Your Honor.
And as far as the $3,000 bond, we think that would be reasonable, and we will make sure that she's at any hearing. However, she does own the house. And we believe that they both, we would like to have no violent contact, Your Honor, as opposed to no contact at all. I think they work well together. She has 2 children that will be in the home. She'd recently, Your Honor, and this may be, she'd had a miscarriage. She'd been suffering some psychological and physical effects from that. And it kind of put her in that emotional state that the officers found her in. There'll be the other conditions, no alcohol, no firearms, all those things are fine. However, she needs to go back to the home so that she can have her children in the home. And I don't believe either are afraid of one another. So we'd ask that it be no violent contact.
Okay, Mr. Wood, I see you there. If you would like to address the court, now is your opportunity to do so. You, of course, do not have to address the court, but if you would like to speak, I'll need for you to raise your right hand for me.
Okay. Yes, sir.
Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Okay. What would you like to tell the court, sir?
It was very situational. It was, my wife is a wonderful woman. It wasn't just a miscarriage, it was a stillbirth. So she was very emotional and has been actually diagnosed with PTSD. We do not have a violent history. She's a wonderful woman, wonderful mother, 2nd grade teacher. I'm not scared. I do not think that there would be any violence whatsoever. I'm sorry that it happened on Saturday, but I think it was very situational. I'm really not concerned going forward.
Okay, and this has not happened in the past?
No, sir.
And you're not afraid of her?
No, sir.
And you would like for her to come back into the household?
Yes, sir.
Okay. Thank you, Mr. Wood. Anything further from counsel?
Nothing from the state.
All right, it's going to be a $3,000 signature bond through pretrial per the judge. 1 day anger awareness, no further violent contact with Mr. Wood, and no drugs, alcohol, or weapons while out on bond. Good luck to you, Ms. Vickers. You also, Mr. Wood, I'm sorry for your loss.
Thank you. Thank you very much, Your Honor. That's the only case. May I be excused?
Yes, have a good afternoon. Thank you.
Thank you, Judge. I'm sorry, Judge. How much was the bond again, please?
It is a $3,000 signature bond through pretrial.
Okay, thank you.
Okay.
Position number 11 is next, please.
Okay.
Case.
Good afternoon, Ms. Taylor. I'm Judge Eric Morrow. This is the state court expedited accusation calendar that we're conducting by video. Do you agree to have your case heard by video? Okay. Ms. Taylor is indicating that she does. And I've also been informed by pretrial that this is Ms. Taylor's first arrest. Mr. Abdullah?
Yes, Your Honor. The facts showed it on January 18, 2023. The defendant called the City of Atlanta Watershed Management on a recorded line and demanded they turn her water back on immediately. The defendant told the call taker when she came to pay her bill, she had her gun on her because she was going to kill a MFer, and she didn't care. This is the defendant's first arrest, but it does pose it's a significant risk to the safety of the employees of the Atlanta Watershed, as well as the general public, that the defendant is making these types of threats. For this reason, the state is recommending a $2,500 surety bond, a stay away from the Atlanta Watershed Department, which is 651 14th Street, except for official business. Nothing further from the state, Your Honor.
Ms. Kim?
Yes, Miss Taylor is 48 years old, and when I was interviewing her, she has a very unique voice, very young. And my client denies this allegation. She does not remember speaking that way. And also, Your Honor, when she went to the She resides in Fairborn, and when she went to pay for her water bill, she remembers that she had to go through the security system to get in, and she does not have any gun. So she doesn't understand where these terroristic threats came from. She denies the allegation. She currently has she's gainfully employed as a project manager at PG Tour. She has a bachelor's degree from University of Florida. She studied political science, Your Honor, and she is indeed a widow. She lost her husband not that long ago. That's why she moved to Georgia to be with her best friend and her father. So we would like to request for a signature on bond. Thank you.
Your Honor, if I could just put on the record that this call was made on a recorded line, and the entirety of the phone call was recorded.
And we definitely would like to verify it may not be her. And we had no chance to hear about that recording yet.
Okay, it's gonna be a $2,000 signature bond through the jail. Stay away from the Atlanta watershed unless they're on official business. No drugs, alcohol, or weapons while out on bond. Good luck to you, Ms. Taylor.
That's all I have in courtroom 3, Judge. Thank you.
All right, thank you.
Position 7, Keys.
Your Honor, this case needs to be in a breakout room.
Okay.
Sorry, I should have let the court know that we can.
Oh, you're fine, Mr. Abdullah. Any other cases that we're gonna need to have a breakout for today? That we know of?
I would like to have a breakout room for Ortega, and I was looking for a position number 9, Your Honor.
Okay, so let's just do them both while we're there. Who is
Sure.
presenting from the state for Mr. Ortega? Do we know?
Your Honor, it is Mr. Rogers.
Oh, okay. So if we can have Mr. Rogers, Mr. Abdullah, Ms. Falk, Ms. Kim. Ms. Kim, are you representing Mr. Keys also?
Mr. Keys, hold on, please, Your Honor. Let me double check. I believe so.
Okay. I
Yes.
just wanted to make sure that we have everyone in the breakout room that we need.
I'm sorry, excuse me, Judge Morrow, before you guys go in the breakout, can we please get the plea paperwork to Officer Norris?
Okay, there's gonna be a plea this afternoon?
Yes, for Mr. Battle.
Okay,
Case.
and who,
Yeah,
Yes.
that's my case, John. I'm about to turn it over.
okay, all right, so we'll
Your
get
Honor,
that.
if I could just check with the Zoom user for the caller that's calling under Zoom user, is that Mr. and Mrs. Key? Trying to get the mic to work. They may be here to speak, but we can go in the breakout room and call them if need be. I believe.
We're here.
Okay, thank you all.
Okay, would it be helpful to have them in the breakout room also, Mr. Abdullah?
Yeah, I think so.
Okay. So if we can go into the breakout room with everyone that was just mentioned, we'll start with Mr. Key's case. All right, so courtroom 2, we're back with Mr. Keys. We've had an opportunity to discuss Mr. Keys's case with lawyers and parents. It's going to be a $3,000 good bond per charge, which makes it a total of a $6,000 good bond. No further contact with Mr. and Ms. Keys at this point in time. Stay away from their residence, which is on Treebrook Court. He's to have an MHET and no drugs, alcohol, or weapons while out on bond, except he's to stay on any prescription medications that he is currently on. Okay, good luck to you.
Excuse me, Judge, who's doing that MHET? Is it the state or Ms. Kim? Okay, will you send that over to me, please? Thank you.
Will I be able to leave my current incarceration? At least say goodbye to my parents, if anything.
You will.
We'll be glad to call you to explain. So please wait. I'll call you at the jail.
I just love to say goodbye to them if I'm not going to be able to see them anymore.
Okay, I don't see them on the line anymore, Mr. Keys, but you can coordinate something with Ms. Kim, okay? In courtroom 2, we've also had the opportunity to talk about position number 9, Mr. Ortega. Is he in the courtroom with you?
Yes, come on, Mr. Ortega. Okay, you're done.
All right, Keys, you got it.
Okay.
I'm gonna take you back.
Which way I go? This way?
No, you go sit.
Okay.
Ortega. Have a seat in the green chair.
Good afternoon, Mr. Ortega. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we're conducting by video. Do you agree to have your case heard by video?
Why not?
And Mr. Ortega, you have been charged in case 23 CR 0000874G with criminal trespass. I've also had an opportunity to discuss your case with your counsel, Ms. Kim, and with the state. This time it's going to be a $1,000 good bond. You're going to have a social worker visit to help you with any housing issues that you might have. You're to stay away from Emory Hospital unless you're there to be treated. You're to have no drugs, alcohol, or weapons while out on bond. Okay, good luck to you, sir.
Thank you.
You're done. Position 6, Jones.
Good afternoon, Mr. Jones. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes.
Thank you. Mr. Jones, you've been charged in case 23 CR 0000872Y with simple battery family violence. I'm told by pretrial that this is Mr. Jones's first arrest. Mr. Abdullah?
Yes, Your Honor. The facts show that on July 4th, 2021, Ms. Demetria Coleman and the defendant were meeting in a parking lot to exchange custody of their 5-year-old daughter. When the defendant noticed Ms. Coleman's partner was in the car, he became upset and irate and attacked Ms. Coleman. He punched her in the face and slammed her door so hard her window shattered. Ms. Coleman's and the defendant's daughter witnessed the altercation and screamed and cried for her dad to stop. After the incident, Ms. Coleman was able to get a protective order against the defendant. That order expired August of 2022. Because of the egregious facts of this case, the fact that the defendant attacked Ms. Coleman in front of their daughter with absolutely disregard for his daughter's safety or Ms. Coleman's safety, the state is recommending a $3,000 surety bond, no further contact with the victim, a stay away from the victim's address, which is 3224 Verdant Drive, no drugs, weapons, or alcohol. And if we could call for the victim at this time.
Yes, Ms. Coleman, I see you there. I'll give you the opportunity to address the court if you would like to. Let me go first to counsel, Ms. McLeod. Good afternoon, Ms. McLeod. Are you representing Mr. Jones?
I am, Lorna, and I'm happy for Ms. Coleman to go first.
Okay, Ms. Coleman, if you would like to address the court, I'll need for you to raise your right hand for me. Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can put your hand down. Thank you, ma'am. What would you like to tell the court?
I more so want to correct him. It's not his first time being arrested. That's one. But more so on my daughter's behalf, I prefer to have it as no violent contact, because he would have to contact me to talk to my daughter. And it's to me, I just want it to be more so on my daughter. Neither one of us matter. It's about her, and that's how I would like to proceed.
Okay, so at the present time, you all do not live together, is that correct?
No, sir.
Okay, and this happened back in 2021. Has anything like this happened since?
No, we haven't been around each other. I do my best to keep my distance and just allow everything to be between him and my daughter.
Okay, and at this point in time, are you afraid of him at all?
I don't want to be in his presence, but I'm not afraid.
Okay. And when there is visitation with your daughter, how is that visitation arranged?
So we supposedly supposed to meet at a certain location to exchange my daughter. But since that incident, my daughter haven't really seen her dad. She might see him through FaceTime on the phone. I tried to meet him in a Publix parking lot to allow her to spend some time with him there, but that's the only thing. It's been FaceTime and that one visit, which was back in December. She haven't really seen her dad. She's been receiving counseling from that event, and it took her a while to actually say, hey, mommy, I want to go and see my dad. So yeah. I don't know.
Thank you, ma'am. Ms. McLeod?
Yes, Your Honor. My client is 32 years old. He has been a native of the Metro Atlanta area for some time. He is currently in college, he tells me, and he's also gainfully employed. I would like to point out to the court that my client is the legitimate father of this child. There is a parenting plan in place, put in place by the Superior Court of Fulton County. So he is the legal father of this child, Your Honor. And based on what the complaining witness is saying, she would like him to have some kind of contact with his child, which is good because it's good for parents to be involved with their children. Also, this incident happened almost 2 years ago, Your Honor, and they do not live together, and they were not in a relationship at this time, and they have not, as she said, been in contact with each other. I would ask the court, given that my client has no criminal history, to give him a signature bond so he can get out of jail, and that there be parenting time that he can see his minor child. I believe the complaining witness said there was at some point in time a restraining order which no longer exists. Third-party transfer of the child is fine with us, Your Honor. Nothing further.
Your Honor.
Yes.
Your Honor, if I could just really quickly, my service went out. I lost service, so I just called back in. I didn't really get to hear the witness testify, but I have a question for her, if you don't mind.
Okay, go ahead, Mr. Abdullah.
So first, I think she said that that was not his first arrest. Ms. Coleman, has she been arrested for assaulting you before, or any type of family violence in the past that you know
I
about?
think they were both arrested at one point in time, and the charges were dropped against both.
That was a question for Ms. Coleman.
I just want the record to be correct.
Yes, ma'am, and thank you for that. But Ms. Coleman, was he arrested for family violence against you in the past?
Yes.
Okay, and I believe you spoke with a victim's advocate this morning. They called you. The day of this attack, was your daughter there? Was she present?
With both.
Mr. Abdullah, she already testified to all of that.
Yes, with both.
I'm gonna, Miss McLeod, I know she has, Mr. Abdullah was having internet problems as we all do from time to time and wasn't here with us. So I'm gonna give him the opportunity to get back up to speed, even if she's talked, even if she's mentioned it. We all have those problems from time to time. Go ahead,
with
Mr.
both,
Abdullah.
Thank you, Honor. Thank
with both incidents, she was present.
you. Okay, and did that traumatize, did that affect on her or her?
So the very first incident, my daughter was a few days from turning 1, so she really didn't understand that. But the second one, which was July the 4th, she was 5 at the time. That one played a major role on her.
Okay. How old is she now?
She is 6. She will be 7 next month.
Your Honor, I just asked those questions just to shed light on the fact that a 5-year-old was traumatized and witnessed her dad assault her mom, which is, you know, for the sake of the child's protection, is probably best that before we allow contact with Ms. Coleman or the child, the defendant receives some type of help regarding his anger, so that the child isn't hurt, or that Ms. Coleman, I understand that there hasn't been any violence in the last year or so, but it's only been a year. I'm sure that the child hasn't forgot what she saw, and so for that request, and
she still kind of speak on it.
And I appreciate you for sharing that, Ms. Coleman. So for that reason, we would just request no further contact with the victim at this time. No further contact with the child as well. And if the defendant would like visitation, he should go through the court and the proper channels to secure it.
Your Honor, may I
This is just a bond hearing on a simple battery family violence. I don't have another charge here regarding the child, Mr. Abdullah. It appears that they are already going through Superior Court with regards to possibly some custody issues. I am always very reticent to keep a father from their child. Just in general speaking, especially here at a bond hearing. So do you have anything further you would like to say, Ms. Cole? Is it Cole or Coleman?
Coleman, I abbreviated in the
Oh, okay. I just wanted to make sure that I have your name right, Ms. Coleman. Okay, go ahead.
So my question is, you stated about our previous court order on behalf of child custody. I tried to proceed with that, but I don't have an address to make those changes for him to be able to see my daughter. And I do agree that he may need some counseling. We tried to get him and my daughter and I some family therapy, but he refused. It's been 2 years and my daughter still seek a counselor every 2 years. So I think that would be helpful for them both to at least, see some type of counseling.
Okay, well, I would encourage you to do that and you to follow up in any way that you deemed necessary. But at this point, as I said, this is a bond hearing for this simple battery family violence. It's going to be a $3,000 signature bond through the jail. No further violent contact with Ms. Coleman and no drugs, alcohol, or weapons while out on bond.
Thank you, Your Honor.
All right, good luck to you all.
Thank you.
Position 10, Steele.
All right, what I want to.
Good afternoon, Mr. Steele. I'm Judge Eric Morrow. This is the state court expedited accusation calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Mr. Steele, you've been charged in case 23 CR 000878B with loitering and prowling and criminal trespass. Is there a history, Mr. Howard?
29 total. You got history out of Illinois, Ohio, and Indiana. Last arrest was back in July for criminal trespass. 2016 misdemeanor possession of marijuana. The Indiana arrest, that was 07 possession of alcohol. Ohio was 2021, obstructing business, ended up being a disorderly conduct conviction. Last arrest in Illinois was 2015, ordinance. 2015, street gang contact / parole. Another 2015, street contact / parole, violation of bail bond. 2014 ordinance, got another street gang contact parole from 2014. 2014, battery making physical contact arrest. And a drug possession, that was a conviction from 2013. I'll leave it there. But he is on probation though.
All right, thank you, Mr. Howard. Mr. Abdullah?
Yes, Your Honor, the facts showed it on February 11, 2023. Officers were called to 1115 Pine Heights Drive in regards to a man trespassing with no shirt and sneaking into the parking garage and trying to get into the building. The suspect from the 911 call, who was later confirmed to be the defendant, also matched the same description from an earlier call regarding a trespasser at the complex across the street at 902 Lenox Hill Court. When officers arrived on the scene, they met with Richard James and Allison Maroney, who both live at the location. They told officers they saw the defendant take his shirt off and try to enter the parking garage and try to gain entry into the building. Ms. Maroney said she was coming home and entered the parking garage when she quickly left because she seen the defendant who tried to approach her with no shirt or shoes on as he walked towards her car. She then called 911. Mr. James also said that he saw the defendant in the building on the elevator without a shirt on. The parking garage and the building are secure access only, and the defendant had to sneak in either behind a resident or break into the building in order to gain entry. Officers searched the area and located the defendant who was identified by Mr. James on the scene. Officers also spoke to residents from across the street who said they seen the defendant climbing over fences and checking doors. As you heard from pre-trial, he does have an extensive arrest history, out-of-state arrest history with 24 cycles out of Illinois. His last arrest out of state was in 2021 in Ohio for disorderly conduct, as well as another 2021 obstruction out of Ohio. For that reason, or for the defendant's out-of-state history, it does pose a significant flight risk, considering the fact that a majority of his arrests have occurred outside of the state, which means that his ties to the community are very weak. He also has an FTA from 2023, as well as another criminal trespass from 2022. For this reason, the state is recommending a $2,000 good bond, no further contact with either witness, Richard James or Allison Maroney, and a stay away from both addresses, 1115 Pine Heights Drive and 902 Lenox Hill Court. I believe the victims have called in today. If we could sound for them.
Okay, I will give them the opportunity to speak if they're on the line. Let me go to Ms. McLeod first.
Yes, Your Honor, my client, Mr. Maurice Steele, is 33 years old. He tells me, Your Honor, that what happened was that he found a Blue Shield insurance card. He was just trying to return it to the owner. My client is currently homeless, Your Honor, and he is trying to find some work, but hasn't been able to find anything recently. He tells me that he does try to maintain a mailing address, and it is at Reverend Black's Church at 1328 Peachtree Street Northeast. That is where he gets his mail, but for the time being, he really is homeless and he's just trying to find a job. He maintains that the reason he was not wearing a shirt at the time of the incident, Your Honor, is that he had just been attacked by someone else and the person had ripped off his shirt. So it may seem a little odd, but that was what he tells me happened, why he was not wearing a shirt. My client is not in a position to pay bond, Your Honor. He's not working and he's homeless. I would ask the court to take that in consideration in setting his bond. He, of course, has no issue with staying away from the locations mentioned by the prosecutor. Nothing further, Your Honor.
If Mr. James or Miss if James or Mulroney are on the line, now's your opportunity to address the court if you choose to. If you would like to address the court, I'll need for you to unmute yourself, activate your camera, and I'll have to swear you in. Richard James or Alex Mulroney. Doesn't appear that they're with us, Mr. Abdullah. As such, it's going to be a $500 good bond per charge, makes it for a total of $1,000 good bond. Ms. McLeod, I would like for there to be a social worker visit so that if the housing is an issue, that we can address that. Possibly Ms. Kim can help us facilitate that.
Yeah.
Thank you, Ms. Kim.
Thank you.
No problem.
Stay away from the Pine Heights Drive address and the Lenox Hill Court address, and no further contact with Richard James or Alex Mulroney. No drugs, alcohol, or weapons while out on bond.
Your Honor,
All
just
right.
for the record, the second victim is Allison Mulroney.
Oh, Allison. Okay, thank you. All right, good luck to you, Mr. Steele.
Thank you, sir.
Position 4, Foreman.
Good afternoon, Mr. Foreman. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes.
Thank you. Mr. Foreman, you've been charged in case 23 CR 000876J with simple battery, family violence, theft by taking, and hindering persons making an emergency telephone call. Is there a history, Mr. Howard?
Judge, my coworker has Foreman. I guess he was on the felony calendar as well.
Okay. Mr. Abdullah, do you have Mr. Foreman's history?
I do.
Okay, if you can give that to the court, please.
For convictions, the defendant does have a firearm, a possession of a firearm during the commission of a felony from 2005, aggravated assault from 2005, a criminal trespass from 2021, and a larceny from out of Mississippi from 2011. In addition to that, the defendant has been arrested for theft by taking in 2014, criminal trespass in 2014, obstruction from 2014. He also has an FTA in 2014, simple assault in 2011, and a battery in 2011. That battery was accompanied by cruelty to children, robbery, and obstruction, all from 2011. He was picked up on this warrant, after he committed an assault on an unborn child, aggravated assault, and a knife during the commission of a felony on February 11. The facts show on this particular case, on October 21, 2022, officers responded to 1605 Peachtree Street, which is a housing shelter. Ms. Felicia Fitch told officers that she was sleeping when the defendant came into her room and started pushing her head to wake her up for a meeting with a caseworker. When Ms. Fitch did not get up right away, the defendant started punching her, and the shelter manager heard the altercation and came to break the two up. Ms. Fitch tried to call 911, but the defendant snatched her phone from her and took her glasses. The defendant told Ms. Fitch he threw her phone outside, but officers were not able to recover it. The defendant fled the scene before officers arrived. And that's the facts from this case. Again, I just would like to point out that that the defendant was arrested February 11th, 2 days ago, on felony charges for an assault on an unborn child, aggravated assault, as well as carrying a knife during the commission of a felony in which he threatened to stab a pregnant woman who was his neighbor. For this reason, the defendant does pose a significant risk of reoffending, not just reoffending, but reoffending for violent crimes. He poses a significant threat to both the general public and the victim of this case, Ms. Felicia Fitch. He also has that FTA from 2014 and several obstruction charges, which creates a significant risk or flight risk. For that reason, the state is recommending a $5,000 good bond. That's $3,000 for the simple battery family violence, $1,000 for the theft by taking, and another $1,000 surety bond for the obstructing person making a 911 call, for a total of a $5,000 good bond. No further contact with Miss Felicia Fitch. Stay away from 1605 Peachtree Street, and no drugs, weapons, or alcohol while on bond. Nothing further from the state, but if we could call for the victim.
Is Ms. Fitch on the line with us? Doesn't appear so, Ms. Abdullah. Ms. McLeod?
Yes, Your Honor. Mr. Courtney Foreman is 42 years old. He is a native of Atlanta, he tells me. He has a 10th grade education and is currently unemployed. He can and has worked at warehouses from time to time. Well, the last time he was actually employed was last year. I understand that the client does have some history, Your Honor, but this incident allegedly happened some time ago. He is not in a relationship with the alleged victim at this time, Your Honor. In fact, he tells me that he is homeless, doesn't have any real place to lay his head, and he was arrested when he was sleeping somewhere out in the open. I just ask the court to take that into consideration in setting any bond for him, because he has no resources at all and no relatives or anyone to help him with bond. Nothing further, Your Honor.
Your Honor, just quickly for the record, he was arrested in an abandoned apartment or in an empty apartment, a vacant apartment, after one of the neighbors or residents of the apartment complex called police officers and reported that he threatened to stab her and kill her unborn child while wielding a knife. Nothing further.
All right, for the simple battery, it's going to be a $1,500 good bond. For each of the other charges, it's going to be a $250 good bond. Makes for a total of a $2,000 good bond. Stay away from the 1605 Peachtree Street address. No further contact with Ms. Fitch, and no drugs, alcohol, or weapons while out on bond. Good luck to you, Mr. Foreman. Who do we have next?
Position 1 battle.
Good afternoon, Mr. Battle. I'm Judge Eric Morrow. This is the State Court Expedited Accusation calendar that we're conducting by video. Do you agree to have your case heard by video?
And Your Honor, I do apologize for interrupting. This is the pro se plea?
Yeah, that's what I thought.
Okay, thank you. Do we have his paperwork ready?
I have not received it.
I sent it in.
To who?
Alton.
Oh, okay. They haven't sent it to me.
They sent a copy back to me. He signed, Mr. Battle signed. I can forward it to you.
Would you please?
Yes, ma'am.
Thank you.
What's your email?
Holly.Bridgewater.
Okay, thank you.
Mm-hmm.
Your Honor, that was another. I'm sorry, I was gonna say there was another case. I didn't mean to interrupt you, but I think it was Weems. I'm not sure. I think we said we were going to address it in the breakout, but we didn't. I just wanted to make you aware of it. I'm sorry.
Okay.
Now I see where this case was heard on. Was it Saturday? Because
Yes,
I have
it's a reset.
Okay, so it is a reset from Saturday.
Yes.
But I have a plea, a order signed by the judge in this. So is that in the error?
Well, I'm not sure what happened, but the notes on Odyssey say that it was a reset per judge's order. I think he wanted to get a social worker to talk to him, or.
Okay, hold on. I'm
I think it
showing
was-
back on February the 11th, they got a $3,000 good bond signed by Judge Williams. Is that not, I mean, I'm holding it right here.
Right, yeah. So he was heard on. I wasn't here Saturday, but from what I see, he was held on. He was heard, and I guess they wrote the bond. But the notes on Odyssey say that the judge reset per judge's order for a social worker visit. If you give me 1 second, I'll pull those notes up.
This Ms. Kim's case?
No, Your Honor, this is.
No, we're talking about Weems, Ms.
Oh,
Kim.
Weems. Yes, Williams is my case, Your Honor. I apologize.
Okay, and what do we need to do? I see that you sent in a waiver of appearance for him.
Yes,
Um,
I thought he was not going to be able to make it.
well, I don't know if he's able to make it or not, but Mr.
But
Abillo.
that is correct, Judge. It is a waiver of appearance for him.
Okay,
Yes.
so Ms. Falk.
Yes, Your Honor. I just got communication from the victim advocate who was present at the hearing on Saturday. Apparently, the public defender was not able to properly speak with the defendant, so they gave the defendant a bond, much like Your Honor does when we have some issues with the conflict public defender not being present, and then they reset it to give the public defender's office a chance to speak with the defendant.
Okay, and do you need to address anything more today, Ms. Kim and Mr. Williams?
No, Your Honor. Only thing is, though, I will definitely send out social worker services since he's residentially challenged. And yet everything else, I think I can, yeah.
Okay, so he's gonna be back on, he was given a good bond, is that right, Mr. Abdullah?
Yes, it's a $3,000 surety bond.
Okay, so he'll be back on the SAP calendar at some point in time, and hopefully by that time, we'll have the social worker visit done.
Sure.
And I guess, do we need to put on the paperwork, Ms. Bridgewater, that a social worker visit has been requested?
Let me see what they have. I'll put it on there just to make sure.
Okay, thank you.
Okay, all right.
All right, so we've anything further for Mr. Williams today?
Nothing from
further, Your Honor.
All right, so let me go back to Mr. Battle. Again, good afternoon, Mr. Battle. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we're conducting by video. Do you agree to have your case heard by video? Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
I do.
Okay, you can put your hand down. Mr. Battle, you have a right to remain silent. Anything you say can be used against you. You have a right to have an attorney present to represent you in these proceedings. It's my understanding that we have provided you with the services of a public defender today, and that you do not wish to utilize their services, but you wish to proceed pro se and enter into a plea with this criminal trespass charge. Is my understanding correct? Okay, and you do understand that that I would be happy to let you speak with a public defender in this regard, and that I'm not sure what your history is or whether you would be able to get out on a signature bond, but that would be an alternative to pleading guilty to the charge. Do you with that said, would you still like to continue forward and enter into a guilty plea on criminal trespass?
Yes, sir.
Is that a yes?
Yes, sir.
Okay. Mr. Rogers, what is the recommendation from the state?
Yes, Your Honor, the state's recommendation is for Mr. Battle to be sentenced to 12 months, credit for time served for 1 day, with the balance suspended, with a stay away order in place for the Marta North Avenue Transit Station located at 641 West Peachtree Street, unless medical treatment is necessary. Nothing further, Your Honor.
So, so unless you have something holding you, Mr. Battle, this plea is a time served plea, and you understand that you would not be able to go back to the North Avenue station. Was that your understanding of the plea?
Yes, sir.
Okay, have we gotten the paperwork, Ms. Bridgewater?
I have it, yes.
Okay. Again, Mr. Battle, it's my understanding that in case 23 CR 0008882C, you wish to plead guilty to criminal trespass. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this afternoon?
No, sir.
You've been given the opportunity to be represented by counsel. It's my understanding that you declined to be represented by counsel and you like to proceed representing yourself. Is that right?
Yes, sir.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury? Has anyone forced you to plead guilty? And you had the opportunity to go through the plea sheet. Did you go through that sheet line by line? And did you sign that plea sheet at the bottom? Okay. I will accept the plea as negotiated, Mr. Battle. Good luck to you, sir.
All right, Judge, I do have a quick announcement
Okay,
for position 2. They waived their appearance. And of course, you already know that about position number,
13.
yes, that's correct, 13.
and then that takes care of everybody else. Is that right?
That's correct.
Yes, we're completed.
All right, thank you all. I'll see you first thing in the morning. We appreciate y'all.
All right, appreciate you too, Judge.
Okay.
Always, Judge. Always.
Your Honor.
Yes.
I do apologize for interrupting. Position 2, he waived his appearance, but he is now medically reset, Your Honor. We're
Okay.
requesting that he be reset to tomorrow's C calendar.
Okay, so we reset him till 2:14. Thank you, Ms. Gant.
You're welcome.
Okay, with that, Ms. Bridgewater, whenever you're ready.
Okay, I'm trying to forward this plea to Ms. Falk. Okay. All right, let me get on camera. Okay, once again, the reset date is going to be February the 28th. Excuse me, position number 1 took a plea. Position number 2 is medically reset till tomorrow. Position number 3 is reset further notice with a $3,000 SOB through the jail. Position 4 is going to the SAP calendar with a total $2,000 good bond. Position 5 is reset further notice with a $2,000 SOB through pretrial per judge. Position 6 is reset further notice with a $3,000 SOB through the jail. Position 7 is going to the SAP calendar with a total $6,000 good bond. Position 8, SAP calendar with a total $1,000 good bond. Position 9, SAP calendar with a $1,000 good bond. Position 10, SAP calendar with a total $1,000 good bond. 11, reset further notice with a $2,000 SOB through the jail. Position 12, reset further notice with a $3,000 SOB through pretrial per judge. And we already know about position 13. I'm going to add on their social worker visit, and that bond remains the same from Saturday. Are there any questions, comments, or otherwise? That's it, Judge.
You all, thank you. I appreciate everything, and I'll see you tomorrow.
Judge, are you doing the C calendar tomorrow afternoon?
I am.
Okay, great. I just didn't know when to start expecting my flowers to start coming in. So I didn't know whether to come in early or just whatever. But thanks for letting me know. Everybody have a good afternoon. All right.
I guess I better go someplace and pick up some flowers.
Real soon.
All right. Y'all have a good afternoon.
Okay, bye-bye.
And Mr. Howard, I'm on trial. That's why I won't be doing it next Tuesday. Well, ORCA, they have ORCA trials now. So, all right. See y'all later.
Okay, bye-bye.